So that means INEC, foreseeing what may likely happen, they were right when they said, well, from all indications, if we get a judgment close to the period with which we're going to conduct the elections, if INEC feels that it's not sufficient for them the time frame is not sufficient for them to put the party back in the ballot, can they request for an election to be moved based on that?
They have the powers. They have the powers to move the election in that circumstance.
Are you sure that would be safe? Because one of the things that the opposition has often said is that if the election is moved, it's an effort by the courts or INEC or anyone else to favor the APC. Are you sure that would be a smart move on the part of INEC?
No, it will be preposterous for anybody to talk of effort by the court. When there are contestations before a court, whatever the legal position is at the end of the contestation is the position of the law. To be futile to argue about court working with somebody or INEC working with somebody. The truth of it is that if the change comes too close to the election, INEC will be unable, logistics-wise, to put back that party on the ticket, on the ballot, and conduct the election within the time required. I've always given the example, if the judgment finally comes 2 days or 3 days to the election, definitely INEC will need to reprint the ballot unless ballot papers have not been printed. And we know at the moment that ballot papers must have been printed. So if that becomes the case, they will need to reprint. And it will be impossible, I believe, judging from my perspective, I do not know if they have machines or a number of machines that can work wonders, but it will be impossible for them to make that change within that time frame. And I think because we are dealing with legality, to be to argue that is deliberate. INEC did not give the judgment if a judgment comes at such a time. So it will not be something to quarrel INEC about. You remember in 2007, Alhaji Atiku participated in that election, but he got his reprieve to participate from the Supreme Court barely days to the election and after the period for campaign had ended, and he participated in that election under the platform of ACN as a presidential candidate.
Now, you said earlier that the ruling had nothing, or the injunction had nothing to do with the candidate. It just gives the party license to put it to be able to participate in the election.
To be on the ballot.
Yeah.
Yes.
So what happened?
Perhaps, I was going to say perhaps we should clarify the fact that it was not an injunction. The court refused the prayer for injunction restraining INEC from not putting the party, but granted the stay of execution of the last judgment. Okay.
Now, so now you said that it's now up to the party to put a candidate on the ballot, well, to put a candidate forward to INEC. Do you see any problem with the party doing that within the record time that they have? Or did they say
the party has no chance anymore. Matters have proceeded beyond where the party can act. They have to pray for the Court of Appeal to conclude. And clearly from the position of the law, if the Court of Appeal concludes and says the Federal High Court was wrong in ordering the removal of the names, then what it is saying is leave the names there. That does not touch the validity of those names at all. It is the Supreme Court decision that will determine whether those names can validly participate in the election or whether they are not participating. The subsisting judgment of the High Court of Rivers State is still subsisting. And so those names are still invalid and invisible to the law at the moment. It is only if change occurs at the Supreme Court that their status can change. So if those particular candidates that were on the ballot before, that were on INEC notice board or on INEC list, remain to election day, then APC is approaching the election in Rivers State with invalid candidates. Any votes cast for them will be invalid votes. So, and even if they win the election, the party that comes second will get the victory.
Wow. Is that the implication of the matter of Rivers State High Court subsisting?
Yes, because what has happened yesterday is the Court of Appeal answering the question whether the Federal High Court was right in ordering INEC to obey the subsisting judgment and strike out the names of the parties, the candidates that were invalidated from their list. That was the only thing the Court of Appeal is dealing with. The Court of Appeal had had the appeal against the High Court judgment and thrown it out that it was not filed within time, which is why they are now in Supreme Court. So all of the drama playing out in Court of Appeal now has nothing to do with the candidature of the names that APC currently has with INEC, which by the implication of the court judgment yesterday, the court ruling yesterday, are the names that are back on INEC list. It has nothing to do with the validity of those names. That will be determined by the Supreme Court.
So
and the matter before the Supreme Court.
So what's the implication of all of these for the electorate? There seems to be a lot of confusion and uncertainties.
There is confusion. That's why I said what transpired yesterday at the Court of Appeal is a double-edged sword. Yes, it enables the party to be back on the ballot. But if that is all that happens and the party gets back on the ballot with the names it has now, then it has just, let me say it has shot itself on the foot. That judgment, that order has shot it on the foot because it's approaching the election with invalid candidates.
So what's the...
It can only be different if the Court of Appeal, in deciding all the appeals, decides that the products of the direct Congress should have been used to substitute the names that were there. The Federal High Court should have made that order. The second order they prayed for by substituting their names for the names that INEC had on its list. That will automatically vest them with valid candidates because there are no questions of validity pending concerning those candidates. But for the current names that are on the list, it will require the Supreme Court delivering judgment on the appeal that is before it. And one way, magically, one way, deciding that, look, okay, the judgment of the High Court of Rivers State is set aside. It's only then that they can be valid candidates.
Well, Prof, I mean, all of this matters, but there are also some who argue that ordinarily the matter which the appeal court is supposed to rule on in terms of the validity of candidates is supposed to be intra-party matter. And if it's intra-party matter, it's beyond the jurisdiction of that they say the courts had at some point said that they don't want to be the ones determining who the candidates and how they come up with their candidates. It ought to be intra-party matter strictly.
No, that stage has passed. The stage of intra-party decision of who is candidate has passed. The party had that chance and they lost it. Where they are now is a stage where a court has made a pronouncement. And what they need to get a reprieve is that there is a subsequent pronouncement by a court of competent jurisdiction, which is an appellate court, that sets aside that earlier judgment. And that has failed at the Court of Appeal and is pending now at the Supreme Court. So it's only the Supreme Court decision that can solve the problem of invalidity, because that's the only court now of competent jurisdiction discussing the issue of validity of the High Court judgment that invalidated the candidates.
In other words, I mean, the accelerated hearing, you think that all of this will be done way before the time, and even if it doesn't, if it comes too close, INEC will still be bound because they cannot unlawfully exclude anybody if the court rules otherwise.
Oh, yes. If the judgment does not come from the Supreme Court for the candidates that are there now on the record before the election, then the election has been approached with invalid candidates. If the judgment of the Court of Appeal comes before the election and it retains the status quo, then their validity is still, the question of validity is still there. And they will remain invalid because what will resolve the problem of invalidity is the Supreme Court for those particular set of candidates. But if it is the direct primaries candidates that end up having their appeal accepted by the Court of Appeal, then that has automatic effect because there is no question of validity pending concerning those particular candidates.
Do you see that happening in record time, because election is just this weekend and then the next one is less than 3 weeks away? Do you see that happening?
It should have been a difficult thing, but the court is conscious of the fact that election is holding next week Saturday, and whatever it has to do in order to make sense and in order not to be nugatory will have to be done before that time.
Okay, now you talked about confusion the other time in all of this drama, as you called it.
Yes. Yes.
What is the implication of all of this for the electorate? Will they still be able to make up their minds in good enough time? What's the implication of all of this confusion for the electorate?
The electorates are to elect candidates of their choice. What it means now for any electorate or citizen that is interested in voting for APC is that their hope is hanging in the balance until the Court of Appeal concludes what it's doing. If it concludes in the current direction, their hope will continue to hang in the balance until the Supreme Court decides. If the Court of Appeal concludes on the other direction, then their hope, their suffering, or call it long suffering, or anticipation or waiting will come to an end because they will have valid candidates and they can cast their vote. But until that is done, for now, there is no certainty for persons wishing to vote for APC.
Let me ask you, Prof. There are those who are just watching all of this scenario and they just wonder, do you think this stay could have happened if perhaps the issue with the CJN didn't come up?
Well, I'd like to fairly say that I think the Court of Appeal may not have been affected. It's just at this point we speak our thought because the question you're asking is about our opinion, our subjective opinions. I think, in a sense, for me, it makes sense that the Court of Appeal tries to preserve the rest by trying to preserve the chances of APC getting into that election because it says with questions, the resolution of which can lead to APC participating in the election. I think the safe thing to do is to take it from that perspective and to conclude that the court has acted in order to preserve the rest so that whoever wins at the end of the day from the intra-party conflict will have his chance in the elections.
All right, we'll leave it at this interlocutory stage and hopefully look forward to the substantive matters being determined. We appreciate your speaking to us this morning, Prof.
Thank you very much.
Yes, indeed, Professor Richard Mokocha there, and the chair of NBA Omoku branch in Port Harcourt. Well, we'll be back in a moment and focus on another matter entirely. Don't go away.